of today on intellectual property protection and privacy strategies. My name is Trevor Cook. I'm a partner in the London office of Bird & Bird. I've been litigating intellectual property for rather longer than I care to remember, and you can discern that from the fact I've been a partner doing that since 1981. Recent years I've mainly been focusing on patent litigation. Thus you'll appreciate that when in the very first session yesterday we heard from Chris Owens that it's not all about patents, I was slightly disappointed. But indeed, it's not. He's right. And especially away from the manufacturing sector and as one moves into the services sector, where if they're encountered at all, patents tend to be encountered in the murky area of business method patents, of which perhaps a bit more later. But copyright, trade secrets, law and trademarks have a substantial role to play in the services sector. Now, there are two topics we're covering today, intellectual property protection and privacy. Intellectual property, well, it's fair to say, I think, that substantive IP laws have been harmonized to a remarkable extent throughout the world in a process that's been going on since the end of the 19th century, so we should have got some way by now. That culminated in the TRIPS agreement, and perhaps, and it's being taken forward in frameworks of bilateral agreements, regional agreements, and perhaps the most recent international agreement of all ACTA. But and we've taken that harmonization rather further forward in Europe, and indeed we've introduced some unitary IPRs across Europe with effect throughout Europe. Although that harmonization process, that further harmonization process, is itself slowing down as we get some really hard issues in IP where consensus is less easy to build. One of those is, for example, the whole question of first ownership. And we've heard over the last couple of days about the difficulties of first ownership with IP that originates in universities or hospitals. Not only, however, are those differences in actual policy and employment terms and things like that, which have problems for first ownership, but there are real differences in substantive laws, even within Europe. Another issue is the whole IP contractual interface, and there we have differences in Europe, particularly as to copyright. But in contrast to IP, privacy, which is another name for personal data protection, about which we were hearing this morning in the context of corporate transactions, is a relatively new, little harmonized concept internationally. And moreover, many of its variances reflect deep-seated cultural attitudes, consequences, major differences in substantive laws. So this morning we're going to try and cover both these sort of disparate topics, and to do so we're going to have three presentations to start with, focusing on an area that's at the interface of life sciences law, life sciences and ICT, where both IP and privacy issues can interact, the area of electronic health records. And so we'll be hearing first about the situation in Europe, then the situation in the States, and then the situation in Israel. And so those learnings will also be relevant to a number of other sort of interface type areas, such as those of personalized medicine, which are going to become very much more important as we go forward in the future. And then finally, for our final presentation this morning, although, as I said, IP laws are substantially harmonized, and especially in Europe, that's the substantive law. The devil in the detail that can actually matter in practice when you come to enforce these things is in the procedures. And so our last presentation will focus on the interesting experiment we're conducting in Europe on increased harmonization, not only of substantive IP laws, but also of trying to start to harmonize procedures. It'll focus on IP litigation, but bear with us as transactional lawyers, because it's only as a result of litigation that the metes and bounds of IP protection are actually determined at the end of the day. So that's all I've got to say by way of introduction. We'll start the presentations on the electronic health records issue with Ron Zink, who should be well known to most of you, but who is Chief Operating Officer, EU Affairs and Associate General Counsel for Microsoft, based in Paris. He's responsible for Microsoft's European Policy and Government Affairs team, leads substantive and strategic positions on policy issues in Europe, Middle East and Africa, including IP. Before he joined Microsoft in 1995, he worked in private practice, and he's a US registered patent attorney and even an inventor on several patent applications. So, Ron.
I forgot if I get up and stand, there's no microphone. Okay, I'll go over here.
Sorry, there, you can use this one.
Okay. Oh, there is. If I stand. Okay. Is this working? Yeah? Okay. I just walk around is better than sitting down. Well, it's a pleasure to be here. I'm very excited to talk to you a little bit about privacy. My first inclination, as you know, in Europe, there's a rewrite of the 1995 Data Protection Directive, and there's a lot of work that's going into that, and we're on the second phase of consultations in Europe, and there was a deadline on January 15th for filing a consultation response to their latest draft. And so I thought I would go ahead and go through my 29-page response I filed on January 15th for you and read it, but Trevor said maybe that's not the right approach for this audience. So I've shifted gears, luckily, and decided to do a little different presentation. If you think about the themes around privacy, these won't be lost in anyone in the audience, but social networking has obviously changed everything when it comes to privacy. It's hard to go anywhere not hear about what Facebook's up to relative to privacy and worldwide. Cloud computing is another area where as data is flowing around various jurisdictions, it raises privacy and security concerns. And I think in some ways these have been here all along, but cloud computing just exacerbates them because there's so much movement and so much work going on there. And just overall increased connectivity to the internet. Everyone's talking about mobile devices, and I was looking at some stats. In Western Europe, in 2009, the average mobile user downloaded 42 megabytes a month of data. And if you look out, I think it was 2015, that goes up to over 700 megabytes of data. They expect people to be downloading per month from their mobile phones. So a big, big deal when you're connecting all these devices to the internet. What does it mean for your privacy? Jurisdictions, I mentioned the 1995 Data Protection Directive. The U.S. is very active as well. And just in December, they issued 2 reports. One is an FTC report about data privacy, and the second one is from the Department of Commerce. And please don't ask me how these are all going to relate to each other, because they seem to overlap a little bit. And then other countries or regions, of course, are involved. Some have very robust privacy laws. Some regions have none at all. And again, if you get back to cloud computing, what does this mean? So the bottom line is it's imperative for companies to really understand how this all works. With that, I thought I'd show you a 54-second video to set up the next presentation. Okay, this worked seamlessly 10 minutes ago, I swear. I think our issue is the wireless connectivity here is a little bit flaky. Let me look here. I just went down? Oh. Okay, I won't show you a video then. If it comes back up, maybe we'll have a chance to look at this. It's it's how you might communicate about privacy to teenagers and people who are, looking to get out of college and get jobs. But anyway, if I can get my computer to stop looking for it, we'll move to the next segment. It's always fun work from Microsoft because people just expect you know how to do these things like this, right? Very good.
Nee, meine Unterlagen. Wo soll das sein?
It's actually one of it.
Das sein?
All right, let me restart this.
Ja. Nee, meine Unterlagen. Wo soll das sein? Ja,